questions on the basis of the such messages. Today we are having this workshop on the LLP Amendment Act 2021. So first of all, I welcome all of you in this workshop. And further, before starting the discussion on this topic on discussion of the LLP Amendment Act, one thing I would like to say to everyone, during the session, if you have any questions, if you have any queries during the session, you can ask such queries through the chat box, through the, we can say, comment box. We will definitely try to take up all the questions raised by the professional. Further, at the end, after discussion of all the provision, we will keep 10 to 15 minutes on discussion of the question answers. So at that time, if anyone have any question, you can just speak and discuss the questions at the end of the webinar. So let's start this workshop on the LLP Amendment Act. As I can say, already more than 100% has joined this workshop through the YouTube and the Zoom. So let me start one by one on the discussion on the LLP Amendment Act. So LLP Amendment Act, definitely we know, is completely a new thing for everyone. Till now, we have not gone through any amendment under LLP Act. Small amendments definitely regular base pe aate rehte hain, but if I will talk about any big amendment, so there was no big amendment under LLP Act since last so many times. So today in this webinar, we can say we are going to discuss about the LLP Amendment Act, or in this webinar, we are going to discuss about the critical points about the LLP Amendment Act. Definitely, I will not say that within a session of 1 hour, all the doubts will be clear, but definitely we will try to discuss and clear as many as provision we can discuss in this 1 hour. So again, once I welcome all of you on this workshop by the CS Divesh Goyal. So let's start this workshop. And first, before going to discuss any provision of the LLP Amendment Act, I must feel we all should be aware when these amendment came, how this amendment came, and what are the dates. Because we all are the professional, whether we are the company secretary and the chartered accountant. I can see as per my list, mostly the company secretaries have joined this workshop. So as mostly company secretary have joined, we as a company secretary, I must tell you, we all should be aware about not only the provision, but we all should be also aware about the dates and the applicability dates and the date of the Amendment Act. So that's why in my first slide, which you can see on your screen, introduction of the LLP Amendment Act. LLP Amendment Act is one of the biggest amendment under the LLP Act, because since 2008, when this LLP Amendment Act came, practically there are no amendments in LLP since last 13 years or 14 years. So this is one of the biggest amendment in the LLP Amendment Act in last 15 years. That is LLP Amendment Act 2021. It is as big as there was a Companies Amendment Act 2014. Companies Act 2013 was there. So first time in the press release, in the budget speech, in the press release of the 2021, our Honorable Finance Minister have discussed and issue a press release about some amendments under the LLP Act. But finally on the 28th July, that we finally came up with we can say finally they came up with the LLP Amendment Act in the month of the 28th July 2021 with the approval of the both House of the Parliament. So as both House of the Parliament on 28th July has approved the LLP Amendment Bill 2021. And finally it got consent from the President of India on 13th August 2021. We know to make any bill as an act, it is required to take, we can say, consent of the President of India. So on 13th August 2021, we first time received the consent of the President of India to make this bill become the act. So LLP Amendment Act came on the 13th August 2021. And when this act came on the 13th August 2021, it was specifically mentioned under the act that Ministry will applicable the provision of the LLP Amendment Act as and when from time to time. So finally, Ministry have came up with a notification for the applicability of the Amendment Act, applicability of the LLP Amendment Act. So on 12th February 2022, recently, today is the 19th February. On 12th February 2022, Ministry came up with a notification that all the amendment in the LLP Amendment Act will be applicable, will be effective with effect from the 1st April 2022. This is the most important thing. We all should have to take care of this thing. All the amendment in the LLP Act will be applicable from the 1st April 2022. So see, point number one, we are today on 19th February. We are having almost 1.5 months to read, to understand the LLP Amendment Act. So it is my personal suggestion, or you can say it is my request to everyone, in the next 1.5 months, go through all the provision of the LLP Amendment Act. So on 1st April 2021, when this 2022, when this act will came into effect, you will be aware about all the provision. This is the only reason we planned of we can say quick workshop on the LLP Amendment Act, or key takeaways on the LLP Amendment Act. Definitely, as I already said, within a 1 hour, if I will say I will complete, or we will complete the complete Amendment Act, definitely it is not possible. Today, we will discuss the key takeaways from the LLP Amendment Act. Then in next workshop, we will definitely plan some particular points, we can say some particular provisions and the process under the LLP Amendment Act. So today we will start focus from the key takeaways on the LLP Amendment Act. Then in next workshop, we will definitely plan some particular points. Just one request to everyone, please keep your mic on mute right now. So 12 February 2022 is the historical date on which Ministry have issued a notification that all the provision of the LLP Amendment Act will came into effect from the 1st April 2022. So 1st April 2022 is defined as a date when all the provision of the LLP Amendment Act will came into effect. Even on the 12th February 2022, Ministry have also issued the rules for the LLP Amendment Act. Because whenever they change in the act, many places it is mentioned like that, as may be prescribed. So that's why they have mentioned, they have already issued the rules on the LLP Amendment Act also along with the act. So whenever there is any amendment, always there is a question, why there is amendment? What is the need of this amendment? Why there should be an amendment? So I have just prepare some points from the point of view of the government, from the point of view of the committee reports, what are the reasons why they want to have the amendments under the act. So if you can see on my screen, I have mentioned the purpose for amendment in the LLP Act 2018. Number one, the governance look to improve ease of doing business and encouraging startup. We know since last we can say 8 years, since 2014, lot of amendment has made under the Companies Act. The major purpose of that amendment under the Companies Act is ease of doing business and to encouragement of the startup. So as Ministry have already done so many amendments under the Companies Act, now they want to grow the LLP also. Now they want to grow the concept of the LLP also. Definitely ease of doing business they want in LLP also. That's why they have introduced so many provisions under this Amendment Act, which definitely will give an ease to the promoters of the LLP. Next, to encourage the business class to incorporate LLP. As we know, in India, many businesses are working in the form of the partnership firm. So government wants to them to convert their partnership firm into LLP and to start their business in the form of the LLP. So it will be better regulate in comparison to the partnership firm. To make it popular for startups. Right now, LLP is not that much popular for the startup as the company. So by this amendment, by ease of doing business in LLP, they want the startups. LLP should also, we can say, get popular as a startups. Conversion of the partnership firm into LLP we have discussed. To remove the fear of the criminal prosecution for non-substantive minor and procedural omissions and commission in normal course of their business and transaction. What happened? If you will go through the LLP Amendment Act 2008, अगर आप LLP Amendment Act 2008 को read करते हो, तो you will see बहुत सारे ऐसे प्रोविजंस थे, बहुत सारे ऐसे पॉइंट्स थे जहां पे डिफॉल्ट होने पे क्रिमिनल पेनल्टीज मेंशन की हुई थी. अब प्रैक्टिकली इफ आई विल शेयर वन थिंग विद यू, एलएलपी एक्ट हो या कंपनीज एक्ट हो, बोथ आर द सिविल लॉज. सिविल लॉज में आपने कोई प्रोसीजरल डिफॉल्ट किया है या सिविल लॉज में आपने कोई कंप्लायंस नहीं किया है, उसके लिए आपको अगर हम बोले कि जेल में डाल दें या उसके लिए वी कैन से कि प्रोसिक्यूशन कर दे, तो दैट इज नॉट करेक्ट. आप एक फॉर्म नहीं फाइल किया इसके लिए प्रोसिक्यूट नहीं कर सकते, एक फॉर्म नहीं फाइल किया इसके लिए जेल में नहीं डाल सकते। तो दैट्स व्हाई मिनिस्ट्री हैव मेड अमेंडमेंट इन दिस एलएलपी एक्ट एंड लॉट ऑफ प्रोविजंस, lot of penalties converted from the criminal penalties to the civil penalties. So बहुत सारी criminal penalties को civil penalties में convert कर दिया है मिनिस्ट्री ने by this amendment act. So one of the major object of this amendment act is decriminalization of offenses. तो बहुत लेवल पे मिनिस्ट्री ने offenses को decriminalize किया है through LLP Amendment Act. So this was the basic purpose of the LLP Amendment Act, or we can say this was the basic things behind the Amendment Act. One thing as a professional I will share with all of you, if any one of you want to read any Amendment Act, any amendment provision, before reading the Amendment Act or the provision, आप लोग प्लीज ट्राई करो कि उसके पीछे के रीजंस को रीड करना, कमिटीज की रिपोर्ट को रीड करना, बिकॉज जब आप अमेंडमेंट के रीजंस, पीछे के रीजंस को रीड करोगे, कमिटी की रिपोर्ट को रीड करोगे, यू विल अंडरस्टैंड कि अगर कोई अमेंडमेंट आ रहा है तो क्यों आ रहा है, क्या पर्पस है उस अमेंडमेंट के आने का। जैसे जो अभी हमने पर्पसेस डिस्कस किए, ऐसा नहीं है कि ये पर्पस कहीं पे मेंशन है या ये पर्पस मिनिस्ट्री ने स्पेसिफिकली लिख के दिए हैं। दीज आर द पर्पस व्हिच आई कैन से वी हैव फाइंड आउट from the reading of the committee report, from the reading of the provision of the law. So everyone should focus on that, ki why there are amendment, because if there is amendment there should be something for that. So let's discuss most important provision of this amendment act, that is small LLP. Till now, since 2013 we all are having the concept of the small company. So we all having the small LLP concept, the small company concept, but there was no concept like the small LLP. But after this amendment act, now we will have a concept of the small LLP. Now, which LLP shall be considered as a small LLP? So as per section 2(1)(ta) of the LLP Act, small LLP means a LLP, the contribution of which does not exceed 25 lakh rupees or such higher amount, not exceeding 25 crore. The turnover of which the contribution is 25 lakh and turnover of which at the statement of account and solvency of immediate preceding financial year does not exceed 40 lakh. So two conditions are there. Contribution does not exceed 25 lakh and turnover does not exceed 40 lakh. If both the conditions are fulfilled, your turnover is less than 40 lakh and your contribution is less than 25 lakh, then you shall be considered as a small company. But if you will not fulfill even a single criteria, if you will not fulfill any one criteria, then such LLP shall be considered as a non-small LLP. So non-small LLP बनने, small LLP बनने के लिए आपको दोनों कंडीशन फुलफिल करना मैंडेटरी है, कि आपको कंट्रीब्यूशन की कंडीशन भी फुलफिल करनी है और आपको टर्नओवर की कंडीशन भी फुलफिल करनी है। आपका कंट्रीब्यूशन 25 लाख से ज्यादा नहीं होना चाहिए और आपका टर्नओवर 40 लाख से ज्यादा नहीं होना चाहिए। अगर दोनों कंडीशन फुलफिल है, डेफिनेटली यू विल कंसीडर एज अ स्मॉल कंपनी। बट अगर कोई सिंगल कंडीशन भी अगर आपने मीट नहीं की, if you fails to meet even any single condition, then you will not consider as a small LLP. So make sure you all should be consider, if your LLP you want to consider as a small LLP, so in that case both the conditions should be fulfilled. So this is one of the biggest amendment in LLP Act 2000, Amendment Act 2021. Why I'm saying this is the biggest amendment? Because we all were waiting some provision like the small LLP, the provision like the we can say the concept of the small LLP and the big LLP. Till now there is no concept, all the LLP was on the same footage, whether whatever the turnover, whatever the contribution, but now this concept is changed. So this is one of the most important amendment from the LLP Amendment Act 2021. Hope it is clear to everyone. Still, if anyone have any query about the LLP, small LLP concept, you can message, you can mention in the chat box. We will definitely take up that question at the end of the webinar. Second amendment, definition of business. This is always a criteria of discussion. This is always a criteria of, we can say, criteria, ये हमेशा एक ऐसा क्राइटेरिया रहा है कि बिजनेस, एलएलपी क्या बिजनेस कर सकती है, क्या बिजनेस नहीं कर सकती। बहुत डिस्कशंस होते हैं इस पे बहुत we can say कि इस पे doubts होते हैं कि which what are the business which are allowed to LLP. So now they have made amendment in the definition of the LLP. LLP business include, as per the definition of the business, includes every trade, profession. Business include every trade, profession, service, and occupation except any activity which central government may by notification exclude. So they have we can say definition is now very wide. Every type of trade LLP can do, every type of profession LLP can do, every type of service or occupation LLP can do, except agar central government will prescribe the list. Till now central government has not prescribed a list, but central government can prescribe the list of the activities which LLP cannot do. So all these LLP, trading is allowed, profession is trade is allowed, profession, service, occupation is now allowed. These things are now practically specifically allowed under the LLP Amendment Act. So definitely जो business word में एक confusion था, जो business word का एक dilemma था since last long time, वो dilemma, वो confusion अब LLP Act का finally ministry ने reduce कर दिया है. That confusion finally has been removed. So now the definition is very clear under the LLP Act, LLP Amendment Act. Third amendment, they have made the definition of the resident of India. Definition of resident in India. Under section 7, subsection 1 of the LLP. Meaning of resident of India for the purpose of designated partner. The term resident in India means a person who has been stayed in India for a period of not less than 120 days. Now, if a person stay in India for 120 days instead of the 182 days in the financial year, such person can be appointed as a designated partner, can be appointed as a resident designated partner. Earlier, the criteria was mentioned that a person stays in India for 182 days shall be considered as a resident in India. But now that 182 days is reduced to 120 days. So now if a person stay in India for 120 days, such person shall be considered as a resident of India. Next, this is very important provision. If you all have gone through recently, approximately couple of months back, Ministry have made the amendment under Companies Act also. They have made under the amendment under Companies Act also about such provision, names which are not allowed, names which are undesirable. So as per the section 15, subsection 2, clause B, no limited liability partnership shall be registered by a name which in the opinion of the central government is identical to any other LLP, nearly resemble to that of the any other LLP, or a company or a registered trademark of any other person under the Trademark Act. So earlier the guidelines of the LLP name, earlier the LLP name guidelines was not clear. But now Ministry have made the try to clear the guidelines for the name approval of the LLP. Now what will be happen? LLP's name definitely should not be identical to the any other LLP. LLP name should not be we can say similar to any other company name, should not be similar to any other trademark name. So now they try to give the clarity about the name, which type of name is allowed. Definitely in a corner of our mind, this provision was there. These are the things, these type of things was there, but there was no clarity. But now Ministry have tried to give the clarity that which type of name is allowed and which type of name is not allowed under the LLP Act. Next provision. Next is very important provision, change of the name of the limited liability partnership. Before going to discuss this provision, I just let you know some reasons behind this section. First thing, this section is fully substitute. The section 17 of the LLP Act is fully substitute. So जो पुराना section था आज की डेट में 1 अप्रैल से वो completely a new section हो जाएगा. Because sometime happen कि Ministry have made any substitution, some word substitution, some word insertion, but here is no substitution or insertion. Ministry have made the substitute a complete section. So section 17 is completely substituted. Now I let you know the reason behind this section 17 as per the report of the committee, as per the ministry's ministry point of view. See, many time what happened, we have applied for the name of the LLP. and we got that name. But we were not aware that this name is the prefix which we have used in this name is already a trademark of someone else. For an example, you apply for a name Dvesh Goyal and Dvesh Goyal Private Limited, Dvesh Goyal Services Private Limited. You got that name. Like you apply for Dvesh Goyal Professional Services LLP. You got that name. But later on, you came to know, or the other later on, what happened? The name Dvesh Goyal, the prefix which we have used as a Dvesh Goyal, is a registered trademark of someone else. It may happen, but at the time of application of the name, definitely you got that name. Now what happened? We got that name, but the trademark owner came to know that someone else has created an LLP using the prefix which is their registered trademark. So now this section 17 is giving power to such trademark owners, such proprietors, such partnership firms. Let me now tell you the section. As per the amendment, we can say as per the section 17, now section 17 is very clear that if any trademark owner, if any proprietor came to know that his registered trademark is using by any LLP as a prefix of their name, they can make application to the central government within 3 years from the incorporation of the LLP or from the change of the name of LLP. Because आपने LLP बनवा ली, आपकी LLP अप्रूव भी हो गई, नेम भी आ गया, बट ट्रेडमार्क ओनर को इन फ्यूचर पता चलता है कि वो ट्रेडमार्क तो उसका है, हाउ यू आर यूजिंग दैट ट्रेडमार्क. सो उसके पास 3 years है. In case of change incorporation of LLP, 3 years from the date of LLP. In case of change of name, 3 years from the change of name. So from the 3 years from the change of name or incorporation of LLP, वो रीजनल डायरेक्टर को अप्लाई कर सकता है, रीजनल डायरेक्टर को लेटर लिख के मेंशन कर सकता है टू इंस्ट्रक्ट द LLP टू चेंज देयर नेम. डेफिनेटली वो डायरेक्टली आपको नहीं बोल सकता, बट ही कैन मेक द लेटर, ही कैन we can say make the representation to the regional director to instruct the LLP to change their name. So the most important thing जो यहाँ याद रखने वाली है, जो अगर मैं फोकस करूंगा कि ट्रेडमार्क ओनर के पास कितना टाइम पीरियड है. ट्रेडमार्क ओनर्स के पास टाइम पीरियड है 3 years का. ट्रेडमार्क ओनर को 3 years के अंदर अगर वो रिप्रेजेंट नहीं करते तो प्रैक्टिकली अंडर सेक्शन 17 उनके पास कोई राइट नहीं है उस नेम पे. तो ट्रेडमार्क ओनर को यहाँ गवर्नमेंट ने जो राइट दिया है वो 3 years तक राइट दिया है कि 3 years तक तो आप कर सकते हो, पर 3 years के बाद अंडर सेक्शन 17 अंडर LLP एक्ट आपके पास कोई राइट नहीं है. Now what will happen? Trademark owner will write to the regional director and regional director will issue notice to the company. Regional director then company को notice issue करेगा. On the basis of that notice, LLP को notice issue करेगा. LLP have to change their name within 3 months from the receipt of the notice. So this is the provision. Trademark owner के पास power है within 3 years of incorporation of change of name वो RD को application लिख के इंस्ट्रक्ट करने के लिए बोल सकता है LLP को चेंज ऑफ नेम. आरडी जब नोटिस इशू करेगा तो उसके 3 month के अंदर LLP को अपना नेम चेंज करना है. और 3 month के अंदर नेम चेंज करना है. उसके बाद उसको चेंज करने के बाद विद इन 15 days ऑफ चेंज आरडी को इन्फॉर्म करना है कि दे चेंज देयर नेम. उसके बाद द न्यू सर्टिफिकेट शैल बी इशूड. सो दिस प्रोसेस हैव टू फॉलोड बाय एवरी कंपनी. LLP हैव टू फॉलो दिस प्रोसेस. नाउ a question can be raised by the professionals. I was expecting this question from all of you, that what will happen if after receipt of notice within 3 months, LLP don't change their name. Now what will happen? See, ministry is very clear about that. If in 3 months LLP will not change their name, then RD will instruct to the ROC to change the name of the LLP in the master data, and the name will be like this: ABC LLP, whatever is your name is LLP, not complied with the order of the regional director. This will be the full name of the company. ABC LLP not complied with the order of the regional director. Even in rules, ministry have mentioned one very important thing. एक बहुत important provision rules में mention किया उन्होंने. If LLP fails to comply with the order of the RD within 3 months from the receipt of notice, then their name will be changed. The name of the LLP will be changed in the master data, and until unless LLP don't change their name as per the notice, they have to use that name like ABC LLP not complied with the order of the regional director in their every letterhead, in their every board, on their every invoice. So see, आपकी कोई LLP है और उसका नाम ऐसा चेंज हो जाता है, तो how you will represent your LLP anywhere? So this is a matter of this is a very serious concern of matter, that whenever next time we are working for any LLP, we are suggesting any LLP for change of name or incorporation, we have to focus that they should change name in a manner that in future we will not get the notice, and if we receive the notice, we should take immediate action on the notice, so that our name will not be changed in the record of the ministry like we have not complied with the order of the regional director. So this is the another amendment under the LLP Act. Now let me go on the next provision. Accounting and auditing standards. Now a new section has been inserted, section 34A. This is completely a new section under the LLP Act. Section 34A. According to this section 34A, central government now, in consultation with the NFRA, constituted under section 132 of the Companies Act. Now, central government and NFRA will prescribe the standard of accounting and accounting standard for the LLP, along with the recommendation of the chartered accountant with the ICAI. So till now, there is no proper accounting standard, or the we can say standard of accounting for the LLPs, standard of auditing and standard of accounting for the LLPs. But now under section 34A, central government with NFRA will come up with the such standards. Next, compounding of offense. Section 39. Section 39 of the Companies LLP Act is completely substituted by the ministry. Whatever was the earlier section is now completely a new section with effect from the 1st April 2022. That's why I mentioned here, this section is fully substituted, fully changed, fully amended by the LLP Amendment Act. Now, according to this section, the regional director or any other officer below the rank of the ROC can having the power of the compounding. So, compounding की power, अभी हम brief में discuss कर रहे हैं, हम points discuss कर रहे हैं. The power of compounding is vested with the regional director, same like with the Companies Act. So, regional director has power of the compounding wherever fine is mentioned under the section. Now, for an example, if LLP do a default or a non-compliance of any section of the LLP Act, and that section mention about punishable with fine, in such case, the power of compounding is with the RD. In such case, LLP have to file an application with the RD, and RD will start the process of the compounding. So the process of the compounding is same in the LLP Act as per the Companies Act. The complete step-by-step process, of the compounding under LLP Act, we will definitely discuss in our next workshop. Establishment of the special court, section 67A. Section 67A is also a completely new section under LLP Act. Till now, if you will go through the LLP Act, there are no provision like special court. Special court का कोई provision अभी तक LLP Act में नहीं है. It is first time introduced under LLP Act, the provision of the special court. So section 67 is inserted. So like Companies Act में जो special courts के पास power है in case of prosecutions, the section अगर आप LLP के किसी ऐसे section का default करते हैं जिस section में mention किया हुआ है fine and imprisonment and fine, in such case we have to go in the court of law. At that time the power is vested with the special courts. Then section 67B, power and procedure of special court. Definitely when ministry have introduced the concept of the special court, they have to introduce their procedures, their power under the special court. Appeal and revision, section 67C. So 67A, 67B, 67C, all three are the new section inserted under the LLP Act. Earlier this section was not there under the LLP Act. So these are the three new sections under the LLP Act. Appeal and revision. Appeal and revision का provision क्या है? If you are not satisfied with the order of the special court, if you are not in convinced with the consent with the order of the special court, you can go for the High Court for the appeal against the order of the special court. So practically, all the power of the special court which was there under the Companies Act are now same inserted under the LLP Act also. there is a new, we can say, section they have added 68A, that is registration office. For the purpose of exercising powers and discharging functions as confirmed by the central government, the limited liability partnership, the central commission notification establish such number of registration office at such place. Means new registration office, new ROC's office can be there under the LLP Act and the powers can be assigned to them. This is one of the most important provision. I will say, I will definitely say that I require your personal attention. Whoever 200% have joined this workshop, I want your all attention on this section. First, this section is fully substitute. The section 69, penalty on additional fees, the earlier section is fully substitute. And this new substituted section will be applicable from the 1st April 2022. Here it is mentioned that a different fees or additional fees may be prescribed for different class of LLPs, for different documents and return required to be filed under this act. So as per this section, small LLP and non small LLP के लिए different additional fees के provision आएंगे और different forms के लिए different additional fees के provision आएंगे. And this is, I must say, very important provision under the LLP Act, that is additional fees. So we all should properly focus on this provision, that is the additional fees, because additional fees is one of the biggest task under the LLP Act. LLP Act के अंदर additional fees एक बहुत बड़ा task रहा है जब से LLP Act आया है 2008 से, because as per the LLP Act, if company fails to file any form within due date, then LLP have to pay additional fees of rupees 100 per day without any upper cap. For an example, if you made delay of the 300 days to file a LLP form, the additional fees will be 300 into 100, means 30,000 rupees additional fees. I have practically seen many cases, and we, for our client, sometime has paid the additional fees of rupees lakhs in case of LLP. This is one of the biggest drawback. मतलब एक LLP का फॉर्म जिसकी नॉर्मल फीस फाइल करने की 50 रुपए या 100 रुपए होती है, ठीक है, ड्यू डेट में नहीं फाइल किया तो आप उसके ऊपर लैक्स ऑफ रुपीज, मतलब 100 रुपीज साइकिल विल स्टार्ट, then it will be goes on till the date you file the form. There is no upper cap. फिर वो 1 लाख 2 लाख 3 लाख जितना डिले करते जाओगे चलेगा, but practically there was no upper cap. So finally ministry coming with the reduction in the additional fees under the LLP Act. Let me show you the concept of the additional fees under LLP Act. Not only additional fees, they have made changes under Annexure A of the fees. Fees for conversion of firm or company to LLP. If contribution 1 lakh तक है तो ROC fees 500, 1 lakh to 5 lakh 2000, 5 lakh to 10 lakh 4000, 10 lakh to 25 lakh 25,000. So these are the fees for conversion of firm or company into LLP. Now, fees for filing, registering, recording any document, form, statement of account and solvency, annual return means LLP 8, LLP 11, application for conversion of firm or company into LLP. इन सभी की फॉर्म की फीस क्या होगी? एक अगर आपकी 1 लाख तक कंट्रीब्यूशन है तो 50 रुपीज, 5 लाख तक है तो 100 रुपीज, 10 लाख तक है तो 150 रुपीज मैक्सिमम. इफ यू क्रॉस द कंट्रीब्यूशन ऑफ 1 करोड़ then 600 rupees. So we can say these are the very nominal fees. 50 rupees is the fees for the form, is a very nominal fees now they have mentioned. For filing, registering and recording notice of appointment, cessation and change in name, designation, designated partner, intimation of the DPIN, consent to become partner, designated or partner. So name change, partner change, अगर ऐसा कोई फॉर्म फाइल करते हो तो स्मॉल LLP पे है without any criteria of we can say capital 50 rupees or other than small LLP 150 rupees. Any application other than conversion of firm to LLP, if you are going to incorporate a new LLP, then for reservation of name, fees shall be 200 rupees. Director change, for the direction of the change of name, that are the different thing. Now the most important thing, hope this table is visible on your screen. As we have discussed, as per the earlier provision of the LLP Act, if a company fails to comply with, if a company fails to file form within due date, then there was the additional fees of rupees 100 per day without any upper limit. But now the additional fees chart is as mentioned on your screen. First, we will discuss about the small company, then we will discuss about the other than small. So small LLP. If you made delay of 15 days, the additional fees will be one time. Agar aapki normal fees 100 rupees is, the additional fees 200. If delay is 15 to 30 days, if delay is 15 to 30 days, then the additional fees is 2 times, very nominal. 30 to 60 days, 4 times. 60 to 90 days, 6 times. 90 to 180 days, additional fees is 10 times. And 180 days to 360 days is also 15 times. So earlier, if you made delay of the 360 days, you have to pay additional fees 360 into 100, 36,000. But now you have to pay additional fees is 15 times. If your nominal fees is 100, then into 15 is 1500. So you can say from 36,000 to 1500 is a drastic change. Beyond 360 days, other than form 8 or 11, that is 25 times. And for form 8 or 11, that is 15 times of the normal fees plus rupees 10 per day from 361st day. For an example, if I file a LLP 8 within 400 due date, 400 days delay is there, then I have to pay additional fees, and I'm entering into for a criteria of 100 rupees. 15 into 100, 1500, 10 rupees from 361st day. So 40 days into 10, 400. So 15 into 4, 1900 is the additional fees. So this is the new criteria of additional fees, and it is drastically different from the earlier criteria. And if I will talk about the other than small LLP, then up to 15 days one time, 15 to 30 days 4 times, then 8 times, then 20 times, then 30 times. And beyond 360 days, other than form 8 or 11, that is 50 times. 50 times is still lesser than the earlier penalty. Or for form 8 or 11, 30 times plus 10 rupees per day beyond 360 days. So ministry have reduced, we can say, additional fees in a drastic manner. Earlier additional fees हम इतनी additional fees pay करते थे 100 rupees per day के कारण, that without any upper limit. Now there is upper limit. Now we have to pay additional fees not more than this. So I must say, if anyone will ask my personal opinion, I would like to say the concept of the small LLP and the concept of the reduction of the additional fees is one of the biggest relaxation, one of the biggest amendment under the LLP Amendment Act 2021. Hope everyone is clear with the concept. Hope everyone is now clear with the provision of the LLP amendment, provision with the additional fees under LLP Amendment Act. Now let me move to the next provision. Jurisdiction of Tribunal and Appellate Tribunal. Now ministry have changed the jurisdiction of the Tribunal and Appellate Tribunal under the LLP Act, like NCLT and NCLT is now inserted under the LLP Act. Penalty of non-compliance of any order of the tribunal, this section is omitted. General penalty, and this section is also substituted, and this is also important. Right now we have discussed about payment of the additional fees. Now let's discuss about the penalties. Hope you all are aware, whenever a company or whenever a LLP make any default or make any non-compliance, so what happened? For that non-compliance which that LLP or that company has made, not only they have to pay the additional fees, but in except the additional fees, they are still liable for the penalties also. Hope everyone is aware about this. So one point I want to discuss with all of you regarding that, regarding the penalties. What happens if you file any form after due date? Even in the Companies Act is the provision same. If you file any form after due date, you will pay the additional fees. But additional fees is not enough. Additional fees is not enough to make a thing comply. Along with the additional fees, you are liable for the penalty. For that penalty, ROC can issue you the notice of the adjudication under the LLP Companies Act. So under Companies Act, there was a provision of the adjudication. Now ministry have introduced the section 76A under the LLP Act also. This is about the adjudication. And the power of adjudication under section 76A is vested with the ROC, this is the Registrar of Companies. So according to this section 76A, if any LLP make any default, if any LLP made any non-compliance, then ROC having power to issue the notice of penalties. So they like Companies Act now, our LLPs can also receive the notice of the non-compliance from the ROC. So that's why, like Ministry have introduced the concept of the adjudication. So they have made the amendment in the section of the penalties. As per the latest amendment, the limited liability partnership or any partner or designated partner or any other person who is in default shall be liable for penalty of ₹5,000 and in case of continue one with a further fine of ₹100 for each day after the first during the such contribution continue, subject to maximum ₹1 lakh. First thing, अगर LLP के किसी सेक्शन में पेनल्टी मेंशन नहीं है, फाइन मेंशन नहीं है, तो उनको जनरल पेनल्टी का सेक्शन फॉलो करना पड़ेगा, सेक्शन 74, सेम लाइक कंपनीज एक्ट में हम बात करते हैं सेक्शन 450. So if any section of the LLP is not talking about, not mention any penalties or fine, then penalties as per section 74 will be levied. And as per section 74, the maximum penalty for any non-compliance under LLP Act, for the section where the specific penalty is not mentioned, can be maximum ₹1 lakh, ₹5,000 plus ₹100 per day, and maximum is ₹1 lakh. So this is also a very big relaxation to the LLPs. Jurisdiction of the court. Section 77 is also fully substituted. The special court referred under section 67A shall have the jurisdiction and power to impose punishment under section 30 of the Act, that is criminal process. Another thing, see, we have discussed some small amendments, some big amendment here. There are total 29 amendments, 29 sections has been amended by the LLP Amendment Act 2021. Out of 29, as you can see, penalty. Out of 29, 10 sections has mentioned about the change of word fine into penalty. What is the difference from fine into penalty? In case of fine, the power is with the regional director of the compounding. In case of penalty, the power is with the registrar of companies for adjudication. In case of compounding, you have to file an application, then RD will impose the fine. But in case of adjudication, you don't have to file the application. ROC themselves will issue you the notice of the penalty. So almost 10 section, almost in the 10th section of the LLP Act, the penalties has been changed. The word penalties has been amended by the ministry. These are the key takeaways under the LLP Amendment Act 2021. We will definitely have one more workshop on the LLP Amendment Act. In that workshop, definitely we will go through the questions which you will raise even after this workshop. So one thing I just want to share with all of you, one thing I want to say to all of you, please, whoever joined this workshop, you all are having my WhatsApp number. Please drop me a message so that I will share you the link of the Google form which we will create for the next workshop, so that you can raise your query before the workshop. And the next workshop, we will discuss some procedures as well as the queries raised by all of you after this workshop. So today we have discussed some basic and the key amendment of the LLP. One of the major key amendment is the concept of small LLP. Second key amendment is the concept of the reduction of the additional fees. Third key amendment is that ministry have introduced now the compounding process under LLP Act, adjudication process under LLP Act, special court process under LLP Act, change of name guidelines has been mentioned under LLP Act. These are the major points under LLP Act. Now I will do one thing. I will take up your queries which you have raised in the chat box one by one. If anyone want to ask any question, you can even raise your hand. If you are joining through the Zoom, I will definitely allow you to speak and discuss the questions. First person asked, could you please PPT to full screen? Thanks. Okay, that's already done. To classify a LLP, small LLP for 2020-23, turnover of 2021 has to be seen. Yes. See, this provision is going to be implemented from the 1st April 2022. If on the 1st April 2022, you have to see whether your LLP is a small LLP or not, then you have to see the turnover and the contribution as on 31st March 2022. Next, whether reduce additional fees of ₹10 per day for the small LLP is applicable for LLP 3 or 4, pending to be filed since last 2 years. Definitely, Llpic, the additional fees concept, like form 3 and 4 reduced to is applicable for all type of form. They have not made the discrimination on the additional fees. For the additional fees, they mentioned for all the form. There is only one clarity is required from the ministry. One clarity is pending from the ministry. What will happen to the form which are pending before this amendment? See, practically the earlier forms also which are still pending for filing, if we file after 1st April, new provision should applicable, but still we have already seek a clarification from the ministry, but that clarification is pending. Whether LLP can do finance and investment activity as per the RBI guidelines. RBI guidelines does not allow a LLP to do the finance and investing activity. So RBI guidelines are not aligned the same. That's why LLP cannot do such business. Next question, whether reduce of additional fees of ₹10 per day of small LLP is applicable for form 10, 11 or 8 pending to be filed since last 2 years. As I already said, this clarification is still pending to be sought from the ministry. We all are waiting for the clarification from the ministry that the additional fees on the earlier forms also will be as per the new provision or all. But as per my view, my personal view, I cannot say of the ministry view or what, but my personal view, if we file any form after 1st April, it should be accepted as per the new provision, not as per the old provision. Further, I would request to all of you, whoever is joining to the Zoom, you can on your videos also, so we can interact with each other in a better manner also. Next question. For the turnover calculation for small LLP, that is had to be main object only or the other income. See, if we will talk about the turnover is that as per the definition of the LLP, all type of business incomes received by the LLP shall be considered as a turnover. So I can say one of my friend Karan is also there. Thank you, Karan. Next is your query only. From the taxation and compliance benefits, which shall be preferred, LLP and company to client? See, Karan, definitely this is a very important question when we are in this profession. So I can do one thing. It is not possible to discuss this question in one-liner, two-liner or in brief. So let's do one thing. We will, I will just note down this question and we will have a separate session for the half an hour in next week, and we will definitely go through this provision. So the next question, I can see, can a LLP be partner in a company? Definitely, LLP can be the, we can say LLP, अगर company की बात करते हैं तो partner नहीं shareholder बन सकती है. So LLP can be a shareholder in the company. LLPs are allowed to become a shareholder in the company. Lot of companies are there in India whether LLPs are the shareholder. So LLPs are freely allowed to become a shareholder in the company. Let me take up the another questions. If anyone still have any question, please mention that. I will try to definitely take up all of your questions here. How much time is this session already we have done? Sir, what is the meaning of the status defunct of LLP on MC data? See, there definitely many times we have seen there is a status as a defunct LLP in master data, but there is no provision of the defunct LLP. But right now ministry is coming with the provision of the revival of the defunct LLP. So we can say more or less defunct LLP according to them is like a struck of LLP which have not done the compliances. So even as per the new provision, as per the LLP Amendment Act, the provision of the section 252, that is for the revival of the company, shall be applicable on the LLP also. So the same provision which are applicable on the company under 252 shall be applicable on the LLPs also. So definitely now we will have the concept of the revival of LLP under the LLP Act also. Next question. As per the definition of business, can LLP do the manufacturing activity? This is also still a dilemma because they have mentioned about the trade. They have mentioned about the profession. They have mentioned about the services and occupation. But for the manufacturing, they have not clarified that. So we all are waiting for the central government to issue the list of exceptions. So maybe in the list of exceptions, they can mention the manufacturing activity. Next question, can LLP carry on the business of securities trading? As I already said, RBI and the SEBI don't allow the LLP to do the business of the financing, financial activity, or do the business of the security trading. So practically LLPs are not allowed to do the business of the security trading. Next, about fees. Can Form 8 for 2019-20 be submitted after 1st April? As I already said, the clarification is already sought from the ministry on this question. But if you will ask for my view, according to my view, if you find any pending form of the LLP after 1st April, definitely the new provision, the new additional fees should be there. So definitely we may get the benefit of the amendments. Next question. Can we file annual return of 2021 in the month of April for avoiding? Okay, we have already take. Mostly question लोगों के यही है कि अगर जितने फॉर्म आज के दिन में पेंडिंग है 1 अप्रैल के बाद फाइल करते तो क्या एडिशनल फीस रिड्यूस हो जाएगी? एडिशनल फीस रिड्यूस नहीं होगी. So as per the language of the law, additional fees should be reduced, but definitely ministry will come up with the clarification on that. Next, someone mentioned what are the consequences of not change of name. जैसा मैंने अभी बताया था कि किसी LLP ने नेम अप्लाई किया, LLP इनकॉर्पोरेट हो गई है, बट उस नेम में जो प्रीफिक्स यूज किया है, दैट प्रीफिक्स इज समवन एल्स ट्रेडमार्क, एंड उस ट्रेडमार्क ओनर ने 3 ईयर के अंदर मिनिस्ट्री में आरडी को एप्लीकेशन दे दिया है, और आरडी ने जब आपको नोटिस इशू किया उसके 3 मंथ में आप नेम नहीं चेंज करते हैं, तो जो भी आपका एलएलपी का नेम होगा ना, अगर फॉर एन एग्जांपल आपका एलएलपी का नेम है द्वेष गोयल प्रोफेशनल सर्विसेज एलएलपी, तो नेम विल बी लाइक दिस, द्वेष गोयल प्रोफेशनल सर्विस एलएलपी, order of the regional director is not complied with. So this will be a complete name of the LLP, and you have to use this name or your invoices, you have to use this name. We can say everywhere, wherever you mention the name of the company. Can we view the video after live? Definitely this video is will be available on my YouTube channel also. Whenever you want, you can see. Further, one more thing, I am preparing small 5 minutes videos, 5 to 10 minutes videos on the different provision of the LLP. So I'm creating a series so that whenever you want to see any specific provision of the LLP Amendment Act, definitely you can go through those videos also. Is SBO Section 90 provision applicable on LLP? Yes. Just give me one thing. ये वाली sheet भी मैं आप लोगों को show कर देता हूँ, so it will give a better clarity to everyone. Just a second. कि एक point ये है कि मिनिस्ट्री ने एक और amendment किया है कि Companies Act के कुछ section now will be applicable on the LLP. कंपनीज एक्ट के कुछ सेक्शंस की उन्होंने लिस्ट दी है, मैं जस्ट वो लिस्ट गो थ्रू करता हूं. सेक्शन 90 रिगार्डिंग सिग्निफिकेंट बेनिफिशियल ओनर, नाउ दिस सेक्शन 90 विल बी एप्लीकेबल ऑन द एलएलपी आल्सो. सेक्शन 64 164 डिस्क्वालिफिकेशन ऑफ डायरेक्टर, तो 164 1 and 2 will be applicable on LLP. Section 165 1 subsection 1 3 4 5 6, that is about the number of directorship, will be applicable on the LLP. 167 vacation of office of director will be applicable on the LLP. 206 power to call information books, conduct audits, inquiries will be applicable on LLP. Inspection provision 207 will be applicable on LLP. 252 revival provision is now also applicable on the LLP, and 439 office to be non-cognizance. These are the 8 section of the LLP Companies Act. This complete 8 section of the Companies Act will be applicable on the LLPs also now. So next, the notification will applicable for 2020 21 2021. So I think this is regarding to the fees only, उस पे मैं already clarify कर चुका हूँ. Can LLP act holding body corporate of the private limited company? See, as per the Companies Act, any body corporate can be your holding or your subsidiary. So practically LLP can be, yes, LLP can be a holding company, or LLP can be a holding LLP. Next question which I have received is regarding number of directorship will be include LLP and company. Now definitely, as they said, key section of the section 165 number of directorship will be applicable on LLP. So their intention that now the number of directorship will be include the designated partnership position in the LLPs also. Next question, can LLP become 99% shareholder of a company and CFS is applicable? First thing, definitely LLP can be a 99% shareholder of a company, or as per the Companies Act, it is your holding company. But now we are talking about from the point of view of the LLP. So अगर मैं LLP की बात करूंगा तो वो कंपनी मेरी सब्सिडरी बन जाएगी, बट LLP एक्ट में कंसोलिडेशन का कोई भी प्रोविजन नहीं है. सो प्रैक्टिकली हमें कंसोलिडेशन नहीं करना पड़ेगा. Next question, when can clarification about the additional fees or all pending form is expected from MC? Is there any way to seek clarification? Definitely, as I am a regular visitor to the MC also for many things, so whenever I will get any clarification, I will let you know all through my YouTube channel, through my updates. Definitely, what will be the their take on this. Can contribution of LLP reduce? Definitely, you can reduce contribution of LLP anytime. For that, you have to definitely prepare a supplementary deed for the reduction of the contribution, and you have to file the form with the LOC. Next, two more questions we will take. I think all the one question. Apart from filing fees, what other benefits are enjoyed by the small LLP? Benefits like general penalty will be less on them, or definitely once they have introduced the concept of the small LLP, so on the regular basis they will give some benefits to them. Right now they have not given the list, but on the regular basis now they will give the benefits. Like अगर हम Companies Act की बात करते हैं तो we know small LLPs को कितने benefits है जो other LLPs को नहीं है. So hope all the questions and the queries of the professional has been resolved. So thank you so much everyone, as you have given your precious time to this workshop, and almost there was a 200 persons through YouTube and Zoom which has joined. So before ending of the session, I would just request to everyone, if possible, please on your videos, I will definitely take a screenshot and we will just publish our we can say about this workshop. So thank you so much everyone. Thanks for your time, and we can say thanks for your time on Saturdays, because generally what happens on Saturdays are we are busy with lot of things, but still you all guys have given your time. So thank you so much for this, and thanks for on your videos also. So be in touch on the regular basis. Definitely we will have some more workshop. Next week we are planning a workshop on the CSR2, because a lot of questions we have received from the professional on the CSR2. So we are planning a, we can say, practical workshop on the CSR2. So in which we can fill a CSR2 form on the practical basis and we can discuss. So definitely I will share the Google form link with all of you through mail ID or WhatsApp group for joining that workshop also. So thank you so much. Thanks for joining.